Good afternoon. My name is Steve Roth, Chair of Sutherland's Financial Services Practice, and I'd like to welcome you to the Sutherland Webcast, The Price is Right, Predictive Modeling, Big Data, and Price Optimization, Regulatory and Litigation Developments, conducted by Sutherland attorneys Eric Arnold, Tom Curvin, Jane Wilson-Bilik, David Hancock, and Tracey Ledbetter. This is the latest in our series of webinars devoted to litigation and related regulatory issues faced by the insurance and financial services industries. We'd like to welcome back those of you who joined us for our previous installments, and would also like to welcome those of you who are new to this series. If you'd like to receive CLE credit for the webinar, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. Should you have any questions during the webinar, please submit them via the Ask the Question text box on your viewing console, which you hopefully can see. Predictive analytics, fueled by big data and driven by our constant use of smartphones, apps, and web browsers, are increasingly used by insurers in marketing and distribution, underwriting, enforced management, and claims. Recently, certain uses of predictive modeling and pricing P&C personal lines policies, dubbed price optimization by many, have drawn the attention of state regulators, consumer advocates, and even class action plaintiffs. Regulators in Maryland, Ohio, California, and New York have addressed the topic. The National Association of Insurance Commissioners has formed a price optimization task force to study the issue, and class actions challenging price optimization have been filed in at least 2 states. In today's presentation, the Sutherland team is going to focus on potential regulatory and litigation issues associated with price optimization and related practices, not just for P&C or multi-line carriers selling personal lines, but also for life companies issuing life insurance and annuity products. And with that, it's my pleasure to turn you over to Tom Curvin.
Well, first, a little context. During our January webinar, which discussed big data predictive modeling more generally as it's being used in insurance and what some of the legal and regulatory and litigation issues were, we ended by mentioning this issue of price optimization. And at that point, one regulator, the Maryland Department, had issued a directive addressing what it called price optimization, and that was in response to, at least in part, concerns by consumer groups and some media coverage of this practice that was dubbed price optimization. Since that time, as Steve mentioned, there have been a host of new regulatory initiatives, a good deal of attention dedicated by the NAIC to price optimization, and indeed the first 2 class action lawsuits filed challenging the practice, and so we thought it would be timely to address this issue. So again, a little context. The starting point to all of this is big data, and the billions of consumer data points that are collected both from an insurance company's own records as well as which are commercially available from third-party data brokers, credit reporting agencies, and data brokers who maintain they are not credit reporting agencies. Examples of this sort of information include motor vehicle records, bankruptcy information, voting registration, consumer purchase data, and in particular online purchase data, web browsing activities, and a myriad of other details about everyday consumer activities. All of that information is being packaged, bundled, and sold, and it is being mined and modeled using highly sophisticated mathematical techniques that we will refer to as predictive modeling. And predictive modeling is the analysis of that data to find statistically significant systematic patterns and then to use those patterns in a business. The P&C side of the insurance industry has really been ahead of the curve. The P&C sector has been using predictive modeling for years, and indeed, if you include consumer credit information in this larger category, for decades. But the life sector is catching up. Increasingly, life insurers are using big data and predictive analytic techniques in underwriting, to examine mortality risks, to flag certain applicants for additional underwriting investigation, and to flag certain applicants for very quick approval and quick ratings. It's being used in marketing on the life side as well as the P&C side, and predictive modeling fueled by big data is being used with in-force policy management. The particular practice we want to talk about today is what's commonly referred to now as price optimization. Now, there are many different definitions of price optimization. The NAIC's Casualty and Actuarial Task Force, which is studying the issue, listed 7 different definitions in its most recent report, issued, updated just last week, in fact. But at the core of all of these definitions is a basic process, and it is this. In rate making, the starting point is using what we will call traditional actuarial techniques and actuarial concepts and actuarial analysis to come up with indicated rates. That's the starting point. And then from those indicated rates, one then moves to the final rates that are filed. And it's that intermediate step that in years past involved a certain degree of subjectivity and business judgment on what the impact of rates would be. That intermediate step, which traditionally has been rather subjective, now in the era of price optimization is highly data-driven and highly analytical. There are analytical models that can be applied that can guide a company in making that step from actuarially indicated rates to the final rates that will be filed. And it's that intermediate process using consumer data and using analytical and algorithmic models that is really in the crosshairs of consumer groups and regulators right now. And that's what, when we talk today about price optimization, it's really that intermediate step. There are, if you look at the different definitions, what they all have in common is, for price optimization, is using statistical techniques and statistical analysis to inform the judgment of how one goes from indicated rates to final rates, and in particular, what the impact of rates would be on consumer purchase behavior. What sort of price increases might the market bear that would be without putting the company at a competitive disadvantage? What sort of price increases would have adverse effects on retention or would prompt additional cancellations? It's that analysis that really is at the heart of this concept of price optimization that's getting so much attention now. So that's what we're talking about today. In the NAIC's most recent report, they refer to definitions of price optimization by the regulators, by various consultants, and by various consumer groups. Now, going from indicated rates based on, again, what we'll call traditional actuarial concepts to final filed rates based on some sort of judgment about what the impact would be on the market and the company's competitive position, that, in the eyes of consumer groups, is highly controversial. In particular, over the last 2 years, as these practices gained more attention, a couple of consumer groups have been quite outspoken in criticizing their view of what price optimization is. The consumer advocacy has been led by the Consumer Federation of America and Rob Hunter, the Director of Insurance, and it has been aided also by the National Consumer Law Center. And here are some of the most significant consumer concerns that have been voiced. First, there is this idea that my premiums will go up based on some mysterious black box calculation that uses information that doesn't seem to have anything to do with actually how risky I am. And A follow-on concern is that I, as a consumer, have no idea of what goes into that black box, so I don't know why and what is driving the price that I'm being charged for my insurance. That is a concern. Another concern is that I will be forced to shop for insurance continually if loyal customers like myself, who really aren't typically highly likely to shop around, don't really want to switch companies. But if I'm penalized by staying with the same company and not shopping around, that's a real disincentive for loyal customers like me. That's a commonly voiced concern. And the final concern, and one that has gotten, I think, a lot of traction and a lot of attention, is that that poor, lower income populations and racial and ethnic minority populations, they will be disproportionately impacted by these practices. This, in particular, is this concern is voiced both by the Consumer Federation of America and by the National Law Center, who expressed the concern that there are certain population groups that tend to overlap with lower income and tend to overlap with certain racial minority groups that have fewer marketplace options. It can be because of geography. There are not a lot of insurance agents around where they are, time constraints, limited transportation, and financial illiteracy. That because of all those factors, that there are certain consumers that tend to shop around less than more sophisticated consumers, and they will be the most vulnerable to these practices of price optimization. And they, according to the consumer groups, depending on how price optimization works, may bear disproportionately higher premiums across larger classes and categories of population. This is, with the Consumer Federation of America, particularly a concern with respect to state-required minimum auto insurance, that there is a high level of concern that people who are buying only the state-required minimum levels of auto insurance, that there is a strong correlation there with lower income and racial minority populations, and that they are going to be acutely impacted by certain price optimization techniques. The National Consumer Law Center also voices the very strong concern that the data inputs that go into the price optimization models, that some of the data may include hidden proxies for race. The National Consumer Law Center is actually referring to this process as weblining, borrowing from the practice of redlining that was thought to plague the mortgage industry years ago. So those are the main concerns that have been voiced by prominent consumer groups. They have been very vocal in voicing those concerns publicly, with regulators, and before the NAIC. So with that context and with that background, let's shift gears and talk about what the state regulators are doing, and then what is the status of this issue before the NAIC. And first we'll turn to the state regulatory landscape, and Mary Jane.
Thanks, Tom. Yes, just to give you some idea of what the state insurance departments have said and how they pick up on the themes that Tom was just mentioning. The first bulletin that was issued by Maryland on Halloween, actually, in 2014, and that's their bulletin on price optimization, which it defines as the practice of varying rates based on factors other than the risk of loss, such as the likelihood that policyholders will renew their policies and the willingness of certain policyholders to pay higher premiums rather than other policyholders. They do not mention the two-tiered notion that you had mentioned, Tom, about interim rates and filed rates. Rather, they are just looking at the fact that these factors are involved in the amount of premium that is assessed. Maryland cites to a presentation made by a consultant to the NAIC Auto Insurance CD study group in July of 2014 that indicated that one of the characteristics of its model on pricing optimization would consider whether a policyholder had complained to the insurer. If the policyholder had complained, this indicated that the policyholder was dissatisfied and was not likely to accept a price increase. As a result, quote, all things being equal, Maryland says that this policyholder would be charged a lower premium than a policyholder who had not complained. So the use of factors such as price elasticity and the willingness of the insurers to accept a premium increase equates to using factors that are not related to the risk of loss in Maryland's view, so that two insurers with the same risk characterizations would be charged different premiums. In Maryland's view, this is unfair discrimination. They cite to their statute that unfair discrimination is discrimination among insurers of the same class based on something other than actuarial risk. And so Maryland required that any insurer who might be taking into account the kinds of factors that it mentions in its bulletin would have to file a corrective action plan and fix their rates by January 1st of this year. Ohio picked up on the same theme. It defined price optimization as the insurer's practice of varying premiums based on factors that are unrelated to the risk of loss in order to charge each insured the highest price the market will bear. And in their view, pricing optimization involves gathering and analyzing data related to numerous characterizations specific to a particular policyholder. So they are using the concept of big data here, and that this data is unrelated to the risk of loss or the expense of such a policyholder, includes information such as whether someone complained, and that from this and similar data, insurers will gather whether there is price elasticity of demand and how much premium the policyholder could tolerate. This is what Ohio writes in its bulletin. It indicates that as a result, two insurers with similar risk profiles would be charged different premiums and would involve discrimination between individuals of the same class based on factors that do not have a demonstrable probable effect upon loss or expense. And they, again, required corrective action, just like Maryland. California was much more accusatory in its bulletin that it issued in February. It's a one-page notice, and it simply declares that price optimization does not seek to arrive at an actuarially sound estimate of the risk of loss and other future losses of risk transfer, and therefore it says any use of price optimization in rulemaking or the pricing process or in the rating plan is unfair discrimination and violation of California law. And companies must immediately cease from using price optimization and refile their rates. The final insurance department that has issued any information about this is New York, which issued a 308 inquiry letter in March of 2015. They are seeking information about price optimization techniques, but they do define price optimization in the same way as Maryland and Ohio, saying it's the practice of varying rates based on factors other than those directly related to the risk of loss, such as setting rates or factors based on individuals' perceived willingness to pay a higher premium. So this is the crux of what the regulators have been concerned about. I was at a conference in New York a couple of weeks ago, and Maryland, Ohio, Michigan, Wisconsin, Maine, and Minnesota also indicated that they are considering this issue. And I know that this has come up at the NAIC. And Eric, you want to talk to us about
thanks,
that?
Mary Jane. This is Eric Arnold. I'm going to talk a little bit about the NAIC's activities in this arena over the last couple of years. As Mary Jane mentioned, some of the first studies of this came out of the Auto Insurance Study Group formed in 2013 and running into 2014. And during the course of 2014, that study group heard presentations from vendors related to price optimization as well as consumer advocates, and collected a bunch of information related to different types of price optimization issues. At the very end of November, at the very end of 2014, that study group decided to kick the issue over to a different NAIC task force and they requested that a white paper be developed on the use of price optimization, and also that white paper explore the regulatory implications of the use of price optimization. Their reasoning for referring the matter over was that the issues went beyond auto insurance and required a lot of actuarial expertise that was better suited to the casualty actuarial and statistical group. So they started that task force's work at the end of 2014. They've been relatively busy already. We're only about 5 months into 2015, and that task force published its initial draft of the white paper in March of 2015. And just last week, on May 7th, they reissued sort of a second draft of the white paper as well. And what I want to do now is just sort of talk very briefly at a high level about what that white paper says and what it does, and then we'll talk about sort of where we think that's headed and what the timing looks like for that white paper. So the white paper is sort of typical with most NAIC white papers. It's kind of trying to create a baseline for the discussion of the issues. And it has a pretty nice scope and background section that describes, as Tom indicated earlier, a number of the different issues created by different forms of price optimization. It identifies and highlights sort of the different definitions that are given for price optimization. And it also eventually gives a sort of a laundry list of potential regulatory responses related to concerns about price optimization. The report's right now about 13 pages long. It does not include at this point any recommendations for next steps. That's left blank and will be advanced over the course of the next several months, we anticipate. Just a couple of sort of high-level points I think we wanted to make on this slide that we thought were very interesting in the white paper as it's currently formulated. I guess the first point is just that in one of the opening paragraphs of the white paper, the task force says that the advent of data mining has allowed the use of more objective and detailed quantitative information about the judgmental aspects of the rate-setting process instead of reliance primarily on anecdotal evidence. So that sort of goes back to, that sort of states Tom's point earlier in this discussion about, coming up with the indicated rates, stepping in with data and information sort of beyond traditional business judgment to come up with final rates. So there's not sort of a per se bias, if you will, against the use of those sort of non-judgmental factors in coming up with the final rates. I think that was important. So at least at a theoretical level, it appears that the task force white paper is going to look at this with an open mind and sort of, at least walk around a little bit some of the categorical rejections from certain of the insurance departments, as Mary Jane highlighted in particular, sort of the California language in that regard. The white paper also includes a section of benefits and drawbacks. So it lists out sort of, this is what consumer advocates have said, these are the drawbacks. It's also listed out some of the proffered reasons for the benefits of the use of this sort of big data to come up with different pricings, different final rates. I'll just mention a couple there quickly. As one of the things that has been highlighted by a number of commenters is that basically the idea that the use of this data allows us, the insurance industry, to come up with better rates, and it provides rate stability to consumers. So that's one of the things they identified. They also sort of clearly focused on and highlighted what Tom referred to as sort of the web lining issues and the issues with respect to lower wealth consumers and their ability to sort of contest or shop around for rates, the elasticity of demand issue, which has really sort of been the hot button here. which is, does it make sense that because I'm a picky consumer and I call my insurance company's line 5 times a year to complain about a nit here and there, that I should not be charged a higher rate simply because I complain. So I think, that point is clearly in there. And I think at least right now, the white paper is citing studies that suggest that the lower income folks clearly don't shop around as much, but it also cites some other studies that suggest that that may not be the case. So it's not sort of clearly cut and dried on that point. And then I just wanted to mention, finally, the white paper concludes with a list of 7 different potential regulatory responses to dealing with the concerns related to price optimization. One of the things that they identified was that there might be price constraints where price optimization is only applied to specific class sizes and not allowing class sizes to be so small that optimization could be applied at the individual insured level. So focusing sort of on at least having small groups. So in my example, rather than basing my rate on the fact that I've called the call center 4 times, you potentially use that data in a broader way, or you don't use that type of data. And a couple of the other examples that are used to really sort of focus on transparency and disclosure. One of them suggests that states could require a specific explanation or reasoning to support any proposed or selected rate or rating factor that deviates from the indicated rate. And then also another possibility would be to require disclosure whenever price optimization is used, including any use of customer demand consideration. So as I said, right now there's a list of 7 things as potential regulatory responses. There is no currently, as I said, any identification of any next steps, and recommended next steps at the NAIC level. I would note that there is a May 19th conference call of the task force where they will be reviewing the most recent draft. I think our best guess is that this task force will probably be scheduling sort of monthly calls between now and I guess they call it the fall meeting in August of the NAIC. And we think they're going to, it seems like they're going to try to move this along relatively quickly so that maybe as early as August they'd either be done with the draft or pretty close to done with the draft. Just one other thing I wanted to mention quickly in terms of regulatory review of price optimization. The Federal Advisory Committee on Insurance met last week on May 7th. And the agenda for those meetings is published in advance. The agenda did not really identify that they were going to be discussing anything, I don't think, about price optimization, but some of the members of that Federal Advisory Committee that provide advice to the Federal Insurance Office are consumer-funded reps, and some of the same presentations that they had given to the NAIC in the last year and a half, or as I understand it, I haven't had a chance to review the video yet, but as I understand it, were given in that meeting. So there are multiple sort of points of contact with this, at least at this point. So we are now going to transition and talk a little bit about litigation developments, and I will turn it over to Tracy.
Great, thanks, Eric. And as we said before, in addition to the regulatory interest that we're seeing from the states and the NAIC, we're also beginning to see some interest from the plaintiffs' bar in the issue of price optimization. Plaintiffs have brought putative class actions challenging the use of what they're calling non-risk-based pricing and what we're calling price optimization in state court in California and Washington. They've alleged that predictive modeling and the use of price optimization allows an auto insurer to charge higher prices based on a consumer's willingness to pay or the consumer's elasticity of demand. They don't explain in the complaint how an insurer identifies those customers who are price insensitive. They simply baldly assert that the insurer will increase the impact of certain rating characteristics that are associated with the willingness to tolerate price increases without really explaining how that's determined or how that's done. But in any event, the allegation is that customers who are not price sensitive and who maybe are loyal to the company that they're with will pay excessive and unfairly discriminatory rates. They do acknowledge that auto insurance rates are filed with the insurance commissioner of the state, but they contend that the insurer hides the use of price optimization from the regulators. They also argue that the use of price optimization violates actuarial standards because, according to them, using a model or a formula to adjust indicated rates isn't the same as using actuarial judgment to do that. So the plaintiffs seek to represent a class of consumers who have been harmed by these alleged violations of state consumer protection statutes, Unfair and Deceptive Trade Practices Act, and also alleged unjust enrichment. Both of these suits were removed from state court to federal court, and the California class action was voluntarily dismissed a few days after removal. This actually wasn't very surprising because if you know California, you know that's a state that has very specific laws and regulations associated with rating, and so in California there's just no room to use price optimization, and it's very unlikely that anybody would use it there. So that case was voluntarily dismissed by the plaintiffs. In Washington, the insurer filed a motion to dismiss, arguing that the case should be dismissed with prejudice under the filed rate doctrine. The insurer argued in the motion that the insurance rates at issue had already been approved by the insurance commissioner. The company was therefore required to charge those rates to its customers, and therefore the court should not reevaluate those rates. And it relied heavily on a recent state Supreme Court case applying the filed rate doctrine in the health insurance context, and it also referred to numerous other cases from around the country. The motion also asserted that the claim should be dismissed for failure to exhaust administrative remedies, and pointed out that the plaintiffs hadn't even attempted to pursue any administrative remedies, and also called on the court to defer to the insurance commissioner's expertise under the primary jurisdiction doctrine. And finally, the motion to dismiss asserted that the plaintiffs had failed to state a claim for unfair and deceptive practices or for unjust enrichment because the plaintiffs had not actually identified any deceptive practices or misstatements and hadn't attempted to allege that they'd relied on any supposed misstatements. And they noted that the plaintiffs, in fact, relied on public filings by the insurance company referring to their use of predictive modeling, pricing strategies, and so on in their complaints. So these things aren't hidden. These class actions both focused on actuarial discrimination that's supposedly caused by price optimization. And interestingly, they don't at this point make any claims about suspect class discrimination. But based on the complaints that Tom talked about earlier that have been raised by consumer groups and sort of history, it's likely that suspect class discrimination claims are on the horizon. Back in the days when insurers began to use credit scores in setting insurance rates, insurance companies faced class action lawsuits alleging racial discrimination and violation of the Fair Housing Act. The argument at that time was that using credit scores had a disparate impact on minorities because, according to plaintiffs, minorities were more likely to have poor credit scores. And as Tom mentioned, these similar types of arguments are being made by consumer groups today, that low-income people, that racial and ethnic minorities have less price sensitivity and aren't willing to shop around because they don't have the same type of options for insurance coverage, and therefore price optimization will have a disparate impact on their rates. And as Eric noted, and as is raised by the white paper, there's some question about whether that's empirically sound. But regardless of whether it is or not, it's likely that the plaintiff's bar is going to pick up on that issue as well, and we'll probably see some cases along those lines. And I think David is going to speak a little bit more about these discrimination issues.
Yeah, if we could pick up with the slide on anti-discrimination law. Hello, everybody. I guess the advantage of speaking on a subject that's still relatively young is that I'm not expected to have 1,000 precedents at my fingertips. But nevertheless, I mean, price optimization fits within some long-established parameters of rate regulation, and it does so sufficiently to allow at least some intelligent commentary on what's been going on. We've divided that analysis, both for sort of tradition and convenience, into categories of suspect class discrimination and actuarial or unfair discrimination. In discussing these next set of slides, I mean, a few preliminary remarks I think are necessary. First, I think it's apparent up to now from the presentation that price optimization kind of falls into two buckets. The first bucket is what we've sort of been calling the black box issue. Where does the information used in price optimization come from? How are these, algorithms structured? How is it used? And Mary Jane will speak after me largely on this first bucket, I guess, using sort of the model or the template from the existing Fair Credit Reporting Act and attempting to situate price optimization into the landscape of consumer privacy laws. But I want to speak on sort of mostly on the second bucket, which is regulator and consumer understanding of the real-world effect of price optimization. And I've read a number of presentations on this, and I've seen some pretty clear assertions that price optimization models have no impact on the determination of actuarially indicated rates. They're just sort of an adjustment from the indicated to final. But I mean, even during the course of this seminar, I received an outstanding question from the listeners, which was, speculating if you could analogize elasticity of demand to an amortization of the acquisition cost of a policyholder, then price adjustment based upon allowing that amortization to run out over a longer premium base is a cost element. And so, I mean, even some of the things that we think are certainties and can state categorically, I think require some serious thought, and we've actually kicked this particular idea around. So I wanted to thank that question. But when we say, okay, this has no application to the determination of indicated, it's just an adjustment to the final, is that the way consumers see it? Because, at the end of the day, somebody's final premium goes up and somebody's final premium goes down. And, we also received an excellent question, asking if this applies to the life side. And I think on the life insurance industry side, which is somewhat in catch-up here, I'm not seeing it so much in the rate determination, but it is clearly coming in, as was alluded to earlier, on issues like guaranteed issue and underwriting expense. And on that side, somebody receives a guaranteed issue offer and somebody does not. So it does definitely apply to the whole spectrum of the industry. But so this is what I want to address primarily. And my overall thesis is going to be, or basically is, that price optimization at this stage is as much a public communication and reputational issue for the industry as it is an actuarial or regulatory law one. And as always is the case, the actuaries and the lawyers just can't talk to each other because, we have to meet regulators and consumers on a playing field that's characterized by their intuitive notions of fairness. And we have, to speak actuary, it means we need to communicate the use of non-parametric concepts in a world where people compare themselves to others parametrically. And you can already see what I mean by the initial regulator reactions to price optimization, as was evidenced in the bulletins we cited earlier. I have in hand the February 18th notice from the California Department prohibiting any form of price optimization because it's not grounded in a risk of loss or estimated future cost of risk transfer. Well, taken literally, that California notice would outlaw all business judgment adjustments to indicated rates, whether done in the manner that's been used in the last 100 years or through modern price optimization techniques. And I somehow doubt that that's what California meant to say. But they did say it, and what's driving what they're saying. So I think the key phrase that sort of summarizes resistance to price optimization is charge what the market will bear. And I think we've heard this in a number of forums. I mean, set aside for the moment that the phrase describes every pair of intersecting slopes on a graph in our Introduction to Economics textbooks when we were in college. You know, I always realized that if two lines touched, that was somehow significant. You know, set that aside. I mean, the insurance industry has always been held to a higher calling, and we should be proud of that. But it tells us that if we pare resistance to price optimization down even further, the optimization boils down to it's somehow unfair. And that's, you know, segues into the slide that's on your screens. So when we discuss discrimination in rate making, right, we always need to differentiate between two different but sometimes intersecting concepts, namely suspect class discrimination and actuarial discrimination. And at the core of actuarial unfair discrimination, you know, as used in the phrase, rates shall not be excessive, inadequate, or unfairly discriminatory, is its opposite concept, which namely is that there is such a thing as fair discrimination. And in turn, fair discrimination depends on the idea that we can divide risks into classes, but not suspect classes, and then in turn treat risks within those classes alike, while having articulable bases for treating one class differently from another class because they're unlike. But as we all know, the notion of class is porous. And you know, we alluded to earlier, how many alike exposure units, which you know we can call people for convenience here, how many exposure units are needed for a class to be a class? You know, one of the fascinating debates currently at the cutting edge of price optimization is whether one can divide people into classes. Now, this is for price optimization and not for rating purposes, not for loss cost determination. But can we divide people into classes of only a few or even one person? You know, now, there's no idea to rule that idea out. You know, those of us who've been involved in small group employer health insurance have long since wrapped our minds around the concept of a group of one. But can we say that in the process of optimizing final premiums to make, can we use classes of a size in that process that perhaps we would not consider credible in the process of developing indicated rates? And there's no law that says we can't, generally speaking, but we need to articulate why we should. So on this current slide, I want to point out the second bulletin, which shows an example of judgment rating that's well known to our life industry attendees. Whether a state mandates unisex rates for life insurance and annuities, or whether a degree of narrowing purely loss-based differentials otherwise comes about in the company's process, non-cost-based adjustments are nothing new to the law, which is part of the reason I have a problem with some of the blanket statements in the regulators' bulletins. I think the third bullet on this slide also serves as a caution that each rate-making regime has to be considered separately when we're talking about the legality of price optimization. In doing this bullet, the one that I had particularly in mind, as Tracy brought out, was that if you're familiar with the California law governing private passenger automobile insurance rating factors, those of you who are familiar with that will appreciate it as just the ultimate in cookbook rate making, where nothing new is allowed to be added to the recipe. Those of you who are also permitted with the rating factor, familiar with the rating factors in that law, know how relatively poorly some of them actually correlate with risk. But we've learned to, live under that law. I mean, it sort of represents the older sibling of price optimization, which is political optimization. So with that, could we bring up the next slide? I'm going to talk about suspect class discrimination, and I don't need to say this, but nobody on any part of this webinar, no person of goodwill anywhere, wants to engage in suspect class discrimination. So we raised the thing because that's the name of the thing. Instead, what really matters for price optimization is the potential for appearances. And this goes back to what I described as the black box problem. When data is being what data is being pulled into these models, what shopping habits, what lifestyle markers, what information from wearable electronics or medical records, etc. Unfortunately, there will be critics who will conflate correlation with causation, and he'll attach sex or gender identity or race labels to the use of these data. And the need to respond to such unfair criticism is because such unfair criticism exists. And that's why I've described price optimization as really as much a corporate communications issue as a purely legal one. So I mean, I raised that just to move on to the next slide to say that it's out there. So if we could bring up on same class or actuarial discrimination.
Okay, David, before you
yes.
get to the next slide, this is an announcement for our listeners who are wanting to receive CLE credit. For those of you who want to receive CLE credit, the confirmation code is baseball, one word, baseball. So please use this code for the sign-in sheet that's available for download there on your computer.
See, you only have to listen to half of what I say to get credit. You know, I touched earlier on some of the basic principles of treating like risks alike and unlike risks, you know, in an unlike fashion, and how this principle translates into regulators' perceptions of what we're doing. But understand that the critics of price optimization are going to be there to focus on any perceived inconsistency. And when a pricing decision is based upon an ever-expanding constellation of data, you know, which data point out of thousands will you be able to say is the one that moved the needle? You know, which one resulted in a better or less favorable final adjustment to rates? And so I think the real takeaway here, both from a corporate communications and a legal unfairness analysis, is that critics of price optimization are always going to rely on their intuition. You know, does something make sense to them as a reason for higher or lower premiums, even if we're only adjusting final premiums at the margin? And a case in point, as we brought up earlier, is one that which we should be all familiar, which is the incorporation of credit scoring into rate making. Opposition, as you all recall, to credit scoring was basically twofold. You know, first, it simply did not make intuitive sense to some people that how they paid their bills affected their risk of suffering an insured loss. You know, second, lacking a common sense correlation in their minds between credit score and risk, the temptation arose to attribute it to some improper motive on the industry's behalf. It's taken 20 years of corporate communication for the industry to shift perceptions sufficiently to allow opinion makers to see that credit and risk, even if they're not directly linked, are second-order reflections of personal responsibility generally. And price optimization, I think, legally and analytically, is at the same early stages of a similar process and reaction. And it's even one that's going to be even more complicated than the credit scoring that we live through, because big data is growing bigger and bigger, and there's really no end in sight. So with that sort of overly theoretical framework, let me turn it over to Mary Jane, who will try to put it into some concrete relationship to the existing Fair Credit Reporting Act.
Thanks, David. Thanks. Yeah, I just wanted to give a couple of points about the Fair Credit Reporting Act and mention that I think most of you are familiar with the Fair Credit Reporting Act and how it governs insurance underwriting information that is received by the insurer from consumer reporting agencies. This includes credit reports that the auto insurance industry receives, or the MIB reports that the life insurance industry receives. And so the FCRA requires that companies keep that information private and that you guarantee that the information you receive is accurate and transparent. And if it applies if a consumer would have to pay more for coverage or receive less coverage, they have to be given certain protections. And now it is enforced by the Consumer Financial Protection Board, the CFPB. And what the FCRA does is give consumers the right to know the contents of the consumer report, to correct any misinformation, to control who has access to their reporting, and to know what specific information that report resulted in either decline of their coverage or higher price or lower coverage. It doesn't apply to first-party information that's collected from consumers, so that if a customer is wearing an Internet of Things device, which is basically a Fitbit or some other kind of device, there is a very specific report by the Federal Trade Commission indicating that those devices are not covered if the manufacturer does their own in-house analytics on that kind of data. It also doesn't cover companies that collect data directly from a consumer's connected devices and then use that data to make in-house credit, insurance, or other eligibility decisions. So FCRA application to price optimization, as we go on the next slide, is somewhat, it's unclear. I know Eric's going to say something more about that in a minute, but the regulators have expressed concerns about the lack of transparency in the data that is received and that is used. It's that black box concept. They've raised issues about negative inferences that might be drawn about consumers based on third-party data that the insurers might be using that's not from credit reporting agencies. They've raised concerns about the inaccessibility of the data so that errors in the data cannot be corrected. And how is it that companies can de-risk those initiatives? Well, part of it is to make sure that when you get the information from data vendors, you get reps and warranties that it is not data that is coming from a credit reporting agency, that you screen the data, you quote, cleanse the data, and you have clarity around the nature of consent that's required for the data usages. And then regulators have also published a report on the Internet of Things that raises these issues, and that report was just issued earlier this year, and that also talks about, of course, as insurers collect more of this data, they're becoming more data risk, and the cybersecurity issues are arising on the security of this information. And there also are the privacy risks that are raised about these very sensitive personal information that is being collected, and the staff recommends that companies engage in data minimization, that they maintain only what information they absolutely need. And let me now turn to Eric, who's going to talk a little bit more about some of the other federal and state issues.
Yeah, thanks a lot, Mary Jane. I'm sort of the part of the program here where I say, unfortunately, we're not done with this yet. We still have to think about a few other things, and we've kind of highlighted those and some of the other sort of regulatory concerns on the last two slides. We just make reference to particular state laws. FCRA does have a certain preemptive effects on state law. There's sort of a complex web of what is and what isn't preempted, but there are also state laws, state consumer information statutes that are not preempted by FCRA, so we still have to be concerned with that. And in particular here, we've referenced the California Investigative Consumer Reporting Agencies Act, which is a very comprehensive set of requirements on a statutorily defined group of companies. So we still have to think about the implications there. And then just finally, I sort of think about this as sort of the baby steps piece of all of this big data and data sharing. You go back to the Gramm-Leach-Bliley Act and HIPAA from at least Gramm-Leach-Bliley going back 15 years, where a lot of clearly articulated privacy standards were put in place for financial institutions. So all of this sharing of information and use of data needs to be compliant with HIPAA, with the Gramm-Leach-Bliley Act requirements that are pushed out to insurers and mutual funds and broker-dealers, among others, banks. And then, there as well, the bad news is that under Gramm-Leach-Bliley, you can have, or good news, depending on your perspective, you can have state laws that are more restrictive, and we've referenced, of course, California state law, which is more restrictive to Gramm-Leach-Bliley with respect to sharing of consumer information. And then finally, of course, you can get tripped up based on your terms of use, and we've seen that in a number of different areas where representations that business enterprises make to their clients that they don't hold true to can ultimately be even more punishing maybe than some of the regulatory issues that they might face. And then we just wanted to conclude, I wanted to conclude with sort of a reference to the Consumer Financial Protection Bureau. I just note, this just came out in the trade press today, there was there was an event held yesterday, sort of co-sponsored by the U.S. PIRG group and the Center for Digital Democracy, and there were speakers there both from the FTC as well as from the Consumer Financial Protection Bureau. The Office of Supervision Policy Assistant Director Peggy Tuhig discussed and laid out the agency's approaches to regulating the potential privacy and data security risks posed by big data or the growing ability of companies to gather, use, and share vast sets of consumer data. So obviously the CFPB is a big and growing regulatory agency. It's got some fences around it in terms of what it can do, but it also, at least I think what we've seen through the initial course of its run, is that it's not shy about moving in and trying to regulate conduct where it thinks there's a consumer issue that it needs to protect. I'm just quoting from this press report. You can see it as a very important topic for the CFPB, and that we're very concerned about these issues in terms of the collection of data on consumers and the use of that data. So it's there's a lot of different eyes on all of these practices, and we need to all be cognizant of all of them, unfortunately. So,
well, we've reached the end of our hour. This is a topic that obviously is not going to recede on the horizon. It looks to be a continued focus of regulatory activity. It looks to continue to be on the NAIC's agenda, and we'll follow closely the class actions that have already been filed, and likely more are on the way. We have several questions. There's a couple of questions about what if any these developments, how they relate to commercial lines insurance. You know, so far the specific practice of price optimization, at least in the regulators' focus, has been on the personal lines P&C side, but the practices of data mining and using predictive modeling, both in underwriting, in-force management, and claims handling, there's no reason to expect that those would be confined to personal lines as opposed to commercial lines. And you know, you've got many of the same concerns over discrimination in rate setting, you know, that could also at least be worth considering on the commercial line side. So it's likely, particularly as the industry as a whole gets more innovative in its use of data mining, predictive analytics, that there will be regulatory and indeed litigation risks in all areas of the sector that are using those techniques.
Well, if I could, we have a number of questions here about how this might apply on the life side, and clearly we see that there are applications here on the life issuing simplified issued policies and how this might play out in that area. But we can say that as far as we know, the regulators have not brought on the life side have not paid attention yet to price optimization. The bulletins I discussed were very specifically related to the P&C issuers in those states. So we'll have to stay tuned to see if once the NAIC issues this and we see further, if the CFPB gets involved, I think you will see some defensive response on the state side. But we will, I don't know if you wanted to say this, Tom, but we will be responding to all the questions and getting back to folks with our thoughts, and we're happy to, please, we know a number of you, if you want to give us a call, we're happy to further discuss these issues.
Yeah, and to finish sort of where we started, as with the use of credit scores and credit data, the P&C side of the industry has been, we would say, ahead of the curve, but in using predictive modeling and big data, the life side is rapidly catching up.
And the life side and the P&C side are merging.
Yeah, they are, and so we expect that many of these same issues will certainly impact the life side, as we go forward, and there's greater use made of these very sophisticated analytical techniques. So just to conclude, we will be, for those participating on the call, we will be sending a follow-up email shortly that will have the slides. We will distribute the slides to everyone who attended. We thank you, as always, for attending this monthly series. Our next regularly scheduled monthly webinar on litigation and regulatory trends affecting the insurance industry is scheduled for May the 9th. So please be on June the 9th. I apologize. Thank you. So please be on the lookout for an announcement, reminder of that date and of the particular topic. And again, thank you for joining us today.
Thank you so much for your attention.